It's such a great pleasure and honor to welcome Professor Toibner to EF State University. Professor Toibner is one of the foremost scholars of law and society, not only in Germany and not only in Europe but worldwide. He's rather well known to the Georgian scholarly public as well. It's not his first visit to Georgia. He has been translated, and I would like to mention the very important contribution, the decisive contribution of Professor Lasha Bakradze, who not only translated him and made his work popular in Georgia, was also invited Dr. Toibner once again to Georgia and to our university. Just a couple of words about his biography. He studied at the universities of Göttingen, Tübingen, and Berkeley, and after writing habilitation at Tübingen University, he became professor of successively the University of Bremen, Florence, and then London School of Economics. After that, he became professor of Frankfurt University, where he published many already classical works. I would like especially to mention here his 2012 monograph Constitutional Fragments, but also his work on law and political system, and I think that admirers of Luhmann will recognize system theoretical direction also in his work. And I'm very glad that I see colleagues from both law school and Faculty of Social Science and Humanities, because Professor Toibner has been working on this overlapping or intersection of these fields, and it's such a great pleasure that we'll have the opportunity to listen to his lecture tonight about the project of constitutional sociology, irritation of the nation state. I don't want to go into detail because I'm not an expert in the field, but we have the best expert of the field here. So the floor is yours. Once again, great pleasure.
Thank you. Rector Magnificus, Spectabilis, ladies and gentlemen, thank you very much for this friendly introduction. Thank you as well for the invitation, and thank you for the ceremony which will follow after my speech, if it goes well. And I'm looking forward to that, and I think this ceremony is a symbol for the ongoing cooperation between Georgian academic life and German or European academic life, especially the context that Professor Bakradze has to Frankfurt, to the excellence class of emergence of normativity, and I hope that these contacts will intensify. I'm going to speak about, as you said, societal constitutionalism, and just to summarize it in one sentence, the whole project is about the activation of civil society as against the concentration of power and possibility of social action on the political system. It's about this widening of politics into society, into different areas of society. I think after years of centralized power, this may be perhaps also interesting here in Georgia.
The project of constitutional sociology, irritating nation-state constitutionalism. The new constitutional question, Google, has become the target of a passionate political debate. The global search engine's 90% market share, its questionable handling of users' private data, and its massive expansionist tendencies into other sectors of the internet raise not only political but also constitutional questions in the strict sense. Experts are warning the public about a private-public gap and a distortion effect in Google's activities, A dominant search engine may have incentives to distort its result in ways that increase its own profits but harm society. This is a matter of constitution, not merely of regulation. While legal political regulation tries to influence actors' behavior externally, from the outside, here the internal structures of the internet and of its collective actors have to be changed. In the case of Google, a constitutional change would imply a division of power, dividing the software provision from the service provision and subjecting them to different legal regimes. A regulatory change would imply the introduction of a regulatory agency to monitor results with confidential access to the search machine's algorithms. So what needs to be transformed is the constitution capillaire, the capillary constitution, which extends to the finest ramifications of digital processes. So, constitution, not regulation, but also not juridification, but constitutionalization of a legal vacuum. That is the challenge. And this indicates a complex interlacing of social and legal processes on the meta level of the internet and their collective actors. So it's not the information processes themselves that form the digital constitution, but rather their architecture, the famous digital code. Perhaps some of you know of Lessig's work. And this constitution covers not only digital code per se, but also its interplay with legal norms, which for their part are not only primary rules, behavior controlling rules, but secondary rules, constitutional norms of a higher rank. Google is exemplary of the new constitutional question. The new constitutional question, which is prompted by the tendencies of globalization, privatization, and digitalization of the world, in comparison to the old constitutional question of the 18th and 19th century, today different, although no less severe problems become apparent. While back then, the focus was on the release of the nation-state's political energies and likewise its effective limitation by the rule of law, the old constitutional question. Today's constitutionalization concentrates on constraining the destructive repercussions that result from the unleashing of entirely different social energies, which are especially noticeable in the economy, but also in science, in technology, and medicine, and the new media. So digital totalitarianism is at the horizon. Constitutionalization beyond the nation state occurs as an evolutionary process going in two different directions. Constitutions evolve in transnational political processes outside the nation state, and simultaneously they evolve outside international politics in the global society's private sectors. Today, transnationalization confronts constitutionalism with three different challenges. First, to analyze empirically ongoing constitutionalization processes beyond the nation state. So it's not just a fantasy and imagination, it's something that goes on at the moment and we have to analyze it. Second, to develop a theory of transnational societal constitutional and its paradoxes. Third, to formulate normative perspectives in politics and law. So I'm going to talk about these three challenges. Challenge number one, empiricism, constitutionalization processes. First and foremost, this is a matter of empirical social research, in which sites, in what types of social conflict, and with what institutional results do actual constitutionalization processes take place in the transnational sphere. Can you hear me well? And yeah, everything all right? Thank you. So, transnational human rights. especially against non-state collective actors. So not the usual stuff, human rights against the state or against public institutions in the transnational world, but against non-state collective actors, so basically the big corporations. Especially against non-state collective actors, horizontal effects of human rights have become apparent. Transnational corporations have committed human rights violations in environmental scandals in Nigeria, the AIDS debacle in South Africa, child labor in the developing countries, land grabbing and biopiracy. It is the global civil society, so the NGOs, the protest movements, that has proven to be the driving force. Transnational human rights do not apply automatically to international organizations or transnational regimes. So for the non-lawyers among you, sounds strange. Huh? Why should human rights only apply to the state? But this is the legal tradition, very firm dogma that human rights and constitutional rights are given against the power of the state, and in the private sectors there are no human rights because there are private law relations. So this is an important step for lawyers to expand the human rights from the vertical dimension, individual against state, to the horizontal dimension, individual versus the big corporations. Transnational rights. So transnational human rights do not apply automatically to international organizations or transnational regimes, not to speak of the private sector. Things become different only when, in the regimes, an independent judiciary begins to develop and constitutional rights are recognized. This is important. So the transnational regimes, they develop judicial institutions, and they begin to apply human rights not only against public authorities but also against private authorities. Then those courts themselves, in a common law-like procedure, so case law, one case after another, in a common law-like procedure are able to determine which standards of fundamental rights should apply within the transnational regimes. Furthermore, protest movements, NGOs and the media are involved in the creation of constitutional rights when they scandalize. Scandalization, that's the very process. Violations of human rights by transnational collective actors. Next field, global economic constitution. Social science analysis of the new constitutionalism, economic studies of an emerging global economic constitution, and international law studies of constitutional norms, a growing significance, have identified constitutional institution of astonishing density in the transnational sphere. Usually we just see this in the national sphere, but no, they develop already on this world level. Today, only very few authors remain to deny that the European Union, despite the failure of the constitutional referendum, has developed a genuine constitution. So not only the nation states, but also the European as such has developed a constitution, although there is not a document like, let's say, in the French Revolution and or the American Revolution. There are documents, of course. In the transnational sphere, the Washington Consensus has politically driven forward the constitutionalization of the global economy, which is based on the autonomy of world markets. However, to produce limitative rules as a replacement for national regulations was not on the agenda, and yes, was even be combated as counterproductive for years. So all the neoliberal agenda in the 90s and early 2000s. Only today, due to the experience of the debacle triggered by the recent financial crisis, collective learning processes that are looking for constitutional limits on the global level seem to be emerging. Next field, transnational regime constitution. International organization, transnational regimes and global networks are by now not only strongly juridified, but also constitutionalized. Despite their fragmentation, they have become part of a worldwide constitutional order. To be sure, this constitutional order does not reach the density of a national constitution. The global institution which originated from the agreements of the 40s of last century, the Havana Charter, GATT, Bretton Woods, the new Washington Consensus institutions, the International Monetary Fund, the World Bank, the World Trade Organization, but also the recent public debate about a global financial market constitution, and the pleas for a worldwide democratic constitutionalism speak the language of actual existing global sub-constitutions. Next field, lex mercatoria, the law of the transnational markets. Above its contractual norms, this self-created law of the global economy has created a layer of constitutional norms. In the lex mercatoria, a hierarchy of norms exists upon whose top are the so-called ordre public d'arbitrage international, the public order of the arbitration, which in fact are constitutional norms, principles, procedural rules, and human rights. And the funny things, I mean, if you know the lex mercatoria, this is not a law created by the state or by public international law contract as usual. It is a law which is just coming out of the contractual practices of the big corporations. It's a purely private law without the usual context of a contract law of the state. Out of nothing, ex nihilo. And funny enough, this kind of private transnational orders, they create their own constitutional procedure, not only legal, not only law, but also constitutional. Detailed analysis of arbitration tribunals identified a variety of such self-created constitutional norms of international arbitration. Self-created constitutional norms. Private arbitration tribunals determine the property principle. Property is one of the most important constitutional rights, freedom of contract, as well as competition rules and human rights as a component of transnational public policy. Next field, corporate constitutionalism. Triggered by a first wave of neoliberal constitutionalization, corporate constitutions focused on providing transnational companies with strong autonomy, corporate governance. The principle of multinational companies' corporate governance consisted of business autonomy, capital market orientation of the organizations, and the establishment of the famous shareholder values. Following the high number of corporate scandals in the last years, the so-called corporate codes of conduct of corporate social responsibility are participating in a second wave of constitutionalization which aims at the limitation of companies' activities. Corporate codes try to break the shareholder orientation and to materialize social responsibility in the sectors of work, product quality, environment, and human rights. And strange again, these public norms, or norms in the public interest, are enacted by private authorities. Last one, global administrative law. More than 2,000 global regulatory agencies were counted. 2,000. This administrative law regulates directly various sectors of the global society that they affect. Through regulation of the social environment, forms of private ordering are emerging, which cannot be captured by the categories of the traditional public administrative law. The constitutional norms that are developed here are in particularly due process of regulation, notice and comment rules, compulsory consultation of experts, the principle of proportionality, and respect for human rights. So far, challenge number one. Now, challenge number two, theory, the ubiquity of the constitutional phenomenon. Constitutions are too important to be left to constitutional lawyers, my dear colleague. In very different disciplines, there are theoretical traditions that criticize the restriction of constitutionalism to the nation state and pose the constitutional question for various sectors of society. The renowned historian Reinhard Koselleck, very famous type in Germany, has offered a fierce critique of constitutional lawyers, namely that they still today focus their attention exclusively on nation states. He demands that the historical reality be recognized, that for centuries not only the nation-state constitution but also the more comprehensive societal constitution has existed, which embraces economic, societal and cultural institutions in a larger constitutional framework. Likewise, Koselleck firmly emphasizes the new transnational constitutionalization. However, due to the state-centeredness of conventional constitutionalism, it is impossible to address the post-statal, in a way, supranational phenomena of our times. This was a citation. In a similar vein, classical sociology did pose the constitutional question not only for the state, but also for all societal sectors. Emil Durkheim established a correlation between basic societal structures, segmental differentiation versus differentiation of labor on the one side, and societal constitutional norms, mechanic versus organic solidarity as a constitutional principle for the whole society. In sociology of organization, the theory of private government has pioneered the debate and revealed the genuinely political character of commercial enterprises and other private organizations, which required the transfer of political principles to private organizations. Within organizations that are apparently exclusively centered around economic efficiency and the profit principle, genuine political power processes could be discovered and analogies to the larger political systems could be drawn. By means of analogy to constitutional state political governments, private governments are required to establish legitimacy through explicit political configuration of organizational rules and ensure their members' sphere of freedom through constitutional rights. The claim to constitutionalism spread through the entire economy. This was the theme of theories of economic democracy. The basis was the political idea of a labor constitution, especially in Germany in the 20s, Sinsheimer, which means a social order which grants workers participatory rights via statute law or collective agreements, again, private agreements, and thus limits exclusive shareholders' rights. With time, this idea has become more generalized. The political constitution is understood as a societal overarching institution, with the consequence that democratic co-determination and guarantees of constitutional rights should be extended from the political process to all socially relevant organizations. Such programs postulate constitutions for all social sectors, following the model of democratic politics. The programs are based on theories of societal transformation, such as Polanyi, which register the unstoppable economization of society, but at the same time also identify social counter-movements that reconstruct the protective cloak of culture-specific institutions against the total economization of society. Economic constitutionalism has been discussed in depth in an exemplary controversy whose representatives in Germany are Hans-Joachim Mestmecker and Rudolf Wiedhölter. Ordoliberal theory claims that property, contract, competition, and monetary institutions form an autonomous economic constitution that emerges not merely from the constitutional law of the state, which has some rules about the economy, but only from the viewpoint of politics, right? But from the interplay of economic self-regulation, economic theories, and legal political norms. The legitimacy of economic constitutionalism is based not on the political decision of the legislator, but primarily on the autonomy of economic action. In contrast, the political theory of law, so this was Mestnecker, now comes Wiethelter. In contrast, the political theory of law focuses on a Verfassungsrecht, whatever this means in German, for all social sectors with the aim of institutionalizing the political as society in society as society. This is formed not just from the democratic unified sum of such citizens, so the political system, but it also organizes institutionalization for decision-making, communication, and education processes. A mature theory of societal constitutionalism was eventually presented by David Schully, starting from Max Weber's Dilemmata of modern rationalization. He poses the question whether there exist any forces opposing the existing massive evolutionary drift toward increasing authoritarianism, not only in politics, but within different sectors of modern societies. Perhaps this is the Georgian experience of the future. Once you got rid of the political authoritarianism of certain Soviet regimes, now you will experience the authoritarianism in societal institutions, in corporations, universities, schools, and so on. So the only social dynamic that in the past has effectively counteracted the drift and in future can offer resistance is, according to Schully, to be found in the institutions of societal constitutionalism. So he invented this concept. What really counts is the social institutionalization of collegial formations that can be identified in specific organizational forms of professions and other norm-producing deliberative institutions within society. So also our little circle makes part of these collegial institutions that carry forward societal institutionalism. Let's march on. Okay, now a concept of the constitution in the transnational context. Transnational societal constitutionalism needs to be built on these theories and ask the question, how far do the principles of nation constitutions have to be generalized in order to avoid the fallacies of methodological nationalism? And how do they have to be re-specified for the peculiarities of diverse societal institutions in a globalized world? Such a method of generalization and re-specification will have to respond to the following problem. Is it possible to identify a transnational equivalent to nation-state constitutions in terms of functions, processes, and structures? In order to qualify as constitutional norms, the norms of transnational regimes have to pass the following quality tests. First, functions, constitutional functions. Do transnational regimes produce legal norms that perform more than merely regulatory or conflict-resolving functions? That is, do they act as either constitutive rules or limitative rules in the strict sense, as we know from the nation constitution? Regime constitutions fulfill the constitutive functions when they formalize the autonomy of their own communicative medium and are doing so on a globalized scale. By means of constitutive rules, the respective constitution regulates the abstraction of a uniform communicative medium, power, in the case of state constitutions, money, law, knowledge, as an autonomous social construct within a worldwide constitutive functional system. For that reason, organizational rules, procedures, competences, and subjective rights are developed, the separation between different social spheres is codified, and thus the functional differentiation of society is supported. So So far for constitutive rules. Now, limitative. Regime constitutions fulfill the limitative function, which is of particular significance today when they develop norms of constitutional self-restraints. Constitutional self-restraints. This is not just a special problem for the political system, but one for all sectors of society. Differences only follow from the respective reproductive conditions. Only politics constructs its constitution to aggregate power and consensus for collective decisions. This is the limited sphere of politics in the constitution, and must use the medium of power for its self-limitation. So fight fire by fire, fight power by power, fight money by money, right? Fight law by law. Other social systems have to align their constitutional limitations on their own communicative media. Constitutional processes. That's the second test. Do the legal norms of regimes develop a sufficiently close connection to their social context or their nomic community, so to the people in the national politics, comparable to that between constitutional norms and the nomic community of nation states? This connection to nomic community is produced by what is here called double reflexivity. This is a central concept, double reflexivity. The primary aspect of constitutionalism and constitutionalization is always to self-constitute a social sphere. Too bad for the lawyers, right? They only come in the second place. So the primary aspect is to self-constitute a social system. The self-constitution of politics, the economy, communications media, or public health. One must take into account the fact that constitutions are primarily social processes and only secondarily legal processes. Montesquieu was before the constitutional lawyers moved in, right? However, such a medial reflexivity does not yet generate constitutions in the technical sense. It enables the self-foundations and not yet the constitutionalizations of social system. Whether in politics, economics, or in other sectors, one can only speak of constitutions in the strict sense when the reflexivity of a social system is structurally linked to the reflexivity of law, that is, to secondary rules. Constitutions emerge when such phenomena of double reflexivity arise, the reflexivity of the self-constituting social system and the reflexivity of the law that supports its self-foundation. So that's the very structure of a constitution. A constitution is not just a document or a bundle of legal rules. No. More complicated. It is first a social process, namely the reflexive application of a communicative medium to itself, power to power, money to money, right? So this is the one side, but this is not enough, and it needs the support of legal reflexivity. So primary rules that regulate behavior, okay, that's fine, but secondary rules on procedure, on competence, or that create the constitution. And only the interplay of these two double reflexive processes creates a constitution which is in itself a process. A constitution is a process, ongoing process of constitutional acts of a political and a legal character, of an economic character, and so on. And finally, constitutional structures. Do the regimes produce typical constitutional structures as they are known in nation states? In particular, the familiar superiority of constitutional rules and judicial review against ordinary law. So the end point of constitutionalization, be it in politics, in the economy, or in other social spheres, is not reached until an autonomous constitutional code, or to be more precise, now comes a Baroque monster, a hybrid binary metacode. Hybrid binary metacode. Sounds not so bad, huh? Arises, which guides the internal processes of both systems involved. The code is binary because it oscillates between the values, now not legal, illegal, but between the values of constitutional, non-constitutional. The code functions at the meta level Because it subjects decisions that have already been subjected to the binary code legal, illegal, to an additional test. So the judges, they decide on is it legal or illegal, and then the constitutional judges, they then decide upon those judgments whether they are constitutional or non-constitutional. The code functions at the meta level, as I said. Legal decisions are tested for whether they comply with the Constitution. Here the constitutional hierarchy arises, the hierarchy between ordinary law and constitutional law. This is what we know from constitutional law of the state, right? The constitutional code of the social sphere concerned is given precedence over the legal code, legal, illegal. Now, what is special about this meta-coding, though, it is its hybridity, hybrid. And hybrid is not a mixture, but hybrid is a kind of double process. So hybridity, as the constitutional code, constitutional, non-constitutional, takes precedence not only over the legal code, as we know, right, but also over the binary code of the function system concerned. Thus, it exposes the binary coded operations of the function system to an additional reflection regarding whether or not they take account of the subsystem's public responsibility. So the political constitution, this means the code constitutional has two sides, the legal side and the political side. Montesquieu was first, and he did this with the political side. Well, only later on the judges came in, right? But the same is within the economy. The economic constitution again has this code constitutional, non-constitutional, and it is about two processes. About one is all the legal rules on the economic system, right? Are they constitutional or not? And secondly, the economic actions themselves are subjected to the public responsibility question of the economic constitution. So only under the condition that a transnational configuration disposes of all these three features, functions, processes, and structures, can one speak of a transnational constitution in a strict sense. So we are not talking about a metaphorical use of constitution or only of an abbreviation or an illusion. No, we have to develop a theory and a clear concept that distinguishes all kinds of legal processes from authentic constitutional law and constitutional processes. Yeah. Now comes the role of constitutions in dealing with foundational paradoxes. If one wants, now it becomes a bit complicated. Up to now it was easy, right? But now, if one wants to understand why political constitutionalism needs to be transformed into societal constitutionalism, one has to realize that not only politics but also other social systems are coping with their foundational paradoxes, and they are coping with it via constitutionalization. The argument has three steps. First step, the law, with the aid of the state constitution, externalizes its original paradox toward politics, while politics externalizes its own paradox toward the law. I explain it later on, just I make the argument short. This is the first point. Second, the law pursues a comparable deparadoxification vis-à-vis other social subsystems. And three, while politics externalizes its paradox completely to the law, other social systems only partially externalize their paradoxes toward the law with the aid of a constitution. Partially, they employ alternative deparadoxifications. This was now in a very condensed form, the argument, and I will explain it a bit. So, first step. As the law is founded on the binary code of right and wrong, legal, illegal, as we know, right? It gets into a tangle with the paradoxes of self-references when the code is inevitably applied to itself. So is it legal or illegal to apply the distinction legal, illegal to itself? This foundational paradox exposes law to the suspicion, which we always had about the law, right? The suspicion of arbitrariness, undermines its quest for legitimacy and paralyzes decisions. The escape routes only lead to the familiar Münchhausen trilemma, Do you know the story of the Count of Münchhausen, who was in a swamp? He was already going down, and then he had the ingenious idea, well, I just pull myself from my hair, right? I've only few hairs, but it works. So the familiar Münchhausen trilemma of the law. Trilemma. Infinite regress. So one norm legitimizes the other, and the next law, and so on and so on. Infinite regress, which we find, for example, in religious natural law. At the end, it ends with God, right? Arbitrary interruption. So you stop this regress at a certain moment. This did Kelsen with the Grundnorm, or the circularity of the foundation of norms, which is Herbert Hart doing. So as none of these three offers a satisfactory way out of the paradox, in the end, only one strategy of de-paradoxification has been found to be successful historically. Law externalizes its paradox toward politics with the aid of the state constitution. Because our legitimacy problems as lawyers, and what's the reason for all these rules you do? I mean, where's the foundation? Yeah, we go on, so we can't find it really. So we move this to politics and use the constitutionalism as the transport means to transport our paradox to the political world, and then we don't care anymore about it. Yeah? So democratic problems will give us the legitimacy, right? Politics, on the other hand, has to struggle with an internally insoluble paradox, the paradox of the binding of necessarily unbound authority. How could one bind the sovereign, the famous sovereignty, to rational rules and above all to its own promises? This was only facilitated when this paradox was externalized toward the law, which once again was accomplished by the state constitutions. So Louis XIV, l'état c'est moi, and he can do what he wants, right? He cannot, because then he becomes bound by the procedures of the law, and what helps here is the constitution. So the constitution commits politically unconstrained sovereignty to the process of the law. The state constitution as a structural coupling between the law and politics is thus characterized by the fact that there is a reciprocal externalization of their paradoxes, of the foundational paradox of law and politics. Law and politics develop complex form of an exogenous self-constraint. So this was the first step. Second step, externalization of the legal paradox to other systems. I was spoken only about the state constitution. Now I speak about other constitutions, right? So it already became obvious in the nation state that the total externalization of legal paradoxes toward the political system would end up in overburdening both law and politics. The over-politicization of law thus demonstrated its most extensive disintegrating effects in the national socialist and real socialist regimes. So the German and the Georgian experience, right? But was also painfully perceptible in the post-war welfare state. Externalization became almost impossible when transnational regimes began to create their own law, as there is no transnational counterpart to the nation-state constitution as the structural link between law and politics, within which externalization could take place. Rulemaking outside the framework of international law that occurs so massively all over the globe reopens all the problems of the legal paradox which had been encountered in the nation state before they had been successfully transferred to politics. Now, in the quest for alternative ways to cope with the legal paradox, the law seems to react by forcing an internal differentiation into subsectors of law and to bypass the political system and base its norm production on other social systems. Diverse social fields are governed by highly specialized legal regimes that are to be considerable extent detached from public international law and now coupled closely with the inner rationality of the social fields. Public regimes, such as the World Trade Organizations, that have come into being as treaties to international law, they marginalize the paradox externalization to politics that had been initially present. They become more and more autonomous. They assert far-reaching autonomy vis-à-vis the nation states and establish themselves as self-contained regimes. That's a new concept in public international law. Self-contained regimes, no longer really part of public international law, generating new forms of structural coupling, and now no longer with international politics, but with the regulated social fields. Public regimes. Private regimes, such as the lex mercatoria, the lex sportiva. You heard about all these scandals in the sports area, and they urgently need a constitutionalization, corrupt as they are, or the lex digitalis, which is just emerging. And they are formed from the very start independently of national law and state treaties. The question of externalizing the legal paradox toward politics does not even arise there. Instead, the original paradoxes of these transnational legal orders are displaced from the very outset into the social fields with which they have entered into a close symbiosis. Now, if the law no longer externalizes its paradox to politics but diverts it to other social systems, this means much more than a simple change of law's self-description. So not only the ideology changes. Since the application of the legal code is itself not only introduces the abstract questions of law's legitimation, which is no longer answered with the legislator's will, but more probably with the inner rationality of the social subsystems involved. So the law not only changes the founding myth, where it conceals its paradoxes, but looks for a different constitutional foundation of its norm production. If it's now no longer the state constitution that is enlisted for externalizing paradoxes, but the constitutions of social subsections, so the economy, the media, science, healthcare, then there are immediate tangible consequences. To say it with Robert Cover, who sees the juris-generative forces of a plurality of legal orders, in the interaction between nomos and narrative, the narrative is not the only one to change when the way that paradoxes are tackled is altered, the nomos itself is converted. When the legal paradox is transformed, other processes of norm production move into the foreground and a different kind of substantive legal norms come into force. So no longer legislation, but contractualization, standardization, and formal organization are the new ways of creating authentic law. Third step, a similar deparadoxification takes place in other social systems. Other social areas also experience reciprocal externalization so that they in turn cede their original paradoxes to the law. The economy has to cope with its own fundamental paradox, the paradox of scarcity. This paradox paralyzes economic actions in such a way that acquisitions of finite goods does away with scarcity. Acquisition of finite goods does away with scarcity, while at the same time generating scarcity. A real paradox. In the past, the only way to overcome this blockage was by replacing the scarcity paradox with a clear-cut binary code of property, non-property. Condensing social positions into binding certainties can only be achieved by a highly developed legal system, so it is the constitution of property that generates a close structural coupling between the economy and the law, and in practice externalizes the scarcity paradox in the law of property. As soon as highly developed monetary economy takes shape, and especially as soon as banks specialize in credit activities, the economic constitution enters a second phase in which the scarcity paradox takes on a completely different form. The economy once again externalizes the paradox, which threatens to paralyze monetary transactions, toward the law. In the banking sector, both the ability and the inability to pay are generated simultaneously. The banking system is based on the paradox of self-reference, on the unity of the ability and inability to pay. This paradox can be mitigated to a certain extent if the payment operations take on a reflexive mode. That is, if operations involving quantities of money are applied to money operations in daily transactions. This hierarchical relation needs to be supported from outside by legal rules. Here we are. In order to constitute the unique position of the central bank with binding regulations. As an economic corollary to the different branches of government, the executive, the legislature, and the judiciary, now the monetative of the central banks, so this is the fourth constitutional power, right, is established by the economic constitution. Despite the parallels with which the economy and politics externalize their paradoxes toward the law, there are weighty differences in the intensity of their constitutionalization. Unlike the state constitution, the economic constitution exhibits a remarkable degree of asymmetry. While it is true, as illustrated above, the law externalizes the legal paradox to a considerable degree toward economic norm production, contract, organization, standardization, it is nevertheless also true, if it is to avoid damaging its structural integrity, the economy can only pursue its legal constitutionalization to a limited extent. Now, third field, what about the constitution of science? I don't go into this in the detail, but again, there we have the paradox of the foundation of science, the famous Cretan paradox, and then the question is, does the law play a role here in this constitution, self-constitutionalization processes of science? And the answer is only to a very low degree, namely the basic guarantee of autonomy of science. So there is also a constitution of science in which scientific and legal reflections are coupled together structurally. Altogether then, societal constitutionalism paints a picture of constitutional pluralism. Although one that is anything but uniform, since it realizes different degrees of intensity of constitutionalizations. All functional systems have to cope with the paradoxes of self-reference, whether they will follow the path of externalizing completely towards the law, as politics chose to do with the legal secondary codification of its operation, or whether they will opt, like the economy, for only a partial externalization toward the law, or whether, like science, they will minimize juridification of their operations. However, this choice depends on the affinity between their own structures and specific normativity developed within the legal system. So we have here a very strange situation. It's comparable to the relation of love, in the sense, that one person loves the other, but it's not said that it's also the other way around. Now, I come to the end. Challenge number 3, normative perspectives, pressures toward the self-limitation of expansive social systems. Today, constitutionalism needs to concentrate on developing limitative rules, not only constitutive rules, for transnational regimes. Now, what's the reason? The reason is that sociology has identified massive expansionary, if not imperialistic or totalitarian tendencies with destructive consequences in various function systems. So I do not speak only about the Soviet Union and Nazi Germany with the expansion of the political sphere, but it is something that happens in many social systems. So in the economy, inherent pressure for over-increasing production is a precondition of its self-reproduction, but the pressure is driven through identifiable mechanisms to such an extent that descent into destructive tendencies is the consequence. So economic totalitarianism, and you have to look a bit to the United States of America to see of the result, to see the results. However, the pressure is found not only in the economy, but also in other functional systems, of course in politics, but also in science and technology. Think of Fukushima. This is not just driven by capitalism. This kind of this totalitarian, this technical totalitarianism, right, which we see there in medicine and in the new digital media. Some people speak of the new digital totalitarianism, which will, cover and conquer our whole world. So, constitutionalism is confronted with the task of developing constitutional rules that are in a position to respond to the motivation competence dilemma that transnational regimes are. Civil society movements, the spontaneous areas of functional systems, the courts and state politics, they develop great motivation in order to limit the expansive tendencies of the regimes. However, what they are lacking is the knowledge, the capacity for action, and the power of implementation that is required to achieve such changes successfully. In contrast, within transnational regimes, these capacities are highly developed. However, due to their interest in self-maintenance, their motivation for self-limitation is mostly missing. In this situation of new obscurity, as said Habermas, the only way out remains a siege of organized professional regimes through a political general public. It is only changes in the internal constitutions of transnational regimes that are able to raise their irritability towards the demands of civil society, courts, and state politics. So it's an interesting outside pressure to our internal constitution. Now we move to the world of art and music. So this is important. Societal constitutionalism is not something that comes out by itself, that the economy begins to constitutionalize by itself. It is a matter of external pressures, strong, powerful external pressures on the economy, on the side of politics, the courts, and especially protest movement NGOs, that may create, if it's strong enough, the internal motivation for self-limitation. But these outsiders, they cannot bring about the changes. It is only within the economic organizations and within the specialists, the experts, that the changes come about. But they need to be pressurized into that. So how such a capillary constitutionalization can succeed in a concrete manner, no one can really predict. Ex-ante prognoses are in principle impossible. Thus, there is no alternative to an experimental constitutionalization. Experimental. Political interventions are indispensable in countering the self-threatening elements of subsystemic rationality, their aim being to introduce new possibilities by breaking down self-blockages, but not to impose on them the rationality of the state. Political and legal regulation, as well as external society influence, are only likely to succeed if the practical form they take is the self-domestication of systemic growth dynamics. This calls for massive external interventions from politics, law, and civil society, but only those designed to translate into self-transformation and whose translation into internal processes of change actually succeeds. Thank you for your attention.
It was very interesting lecture. I can't say that I understand everything, but what I understand, I want to feedback it. As I understand, can we understand the relationship between legal system and politics, economics, or sociality, as a legislation creates the form and the politics, economics, or sociality takes in this form content.
This formula would be a first approximation of the somewhat complicated relations between the law on the one side and different social systems, politics, economy, science on the other. That, in a sense, law creates the formalization, the legal forms, which then are colored by the content. The reason why I say it's only an approximation has to do with the fact that formalization takes place on both sides, right? So the application of power to power, of money to money, is a process of formalization. It's a self-referential process which creates the form of a social system. its autonomy, right? Its autopoietic character and all that, right? So there we find already formalization process. So it's not only content here, form there, but in both areas, in the social field as well as in law, a formalization, but of a different character, takes place. Because the formalization of legal rules is a similar thing. There are the primary rules, behave like this or that. They are formalized in a sense by the secondary rules, by the procedural rules, by the constitutional rules, and so on. So, I mean, the intuition with your question, I think, is quite right. That while law, in a sense, creates the procedures and the formal rules, the substantive content of politics, of the economy, and all this is there and is formalized over there. So in this sense, it's even more than an approximation, but it grasps, let's say, the complicated interrelation in a nutshell.
My question will go perhaps in the direction of simplification of this complexity, for which I apologize. When you mention this constitutionalism as self-limitation of each respective field, there is this first impression, at least, that in this self-limitation, politics plays a kind of decisive role. And this is something which no political scientist or scholar of politics, let's say, can overcome. This first impression that if you would like to limit, let's say, economy, before it can appear to you as self-limitation, political system should kind of make some binding rules for the economic system. And if these can be also extrapolated to any other system. So how would you counter this first impression? What would be your explanation of the somewhat illusory character of this first impression, as far as I understand from your talk? Thank you.
Well, the argument is so well done that I personally cannot counter it, but only can cite one of our literary authorities, Friedrich Schiller, who once upon the time said in English, the state is able, the state is able to destroy art and science, but it's not able to govern in it. Right? So this would be in a nutshell the answer, that indeed, I mean, the state can come with power and legal rules and limit economic action, but also scientific action, censorship, but also in a positive sense, fight capitalism or something, right? But the state can only destroy it either wholly or partially. Cannot do else. It can come with, but it cannot really govern within the economy or within science or within art or even within in law. So this is the limitation of politics. So I agree with you that especially for certain accesses we just need destruction of certain economic excesses, for example, right? But if we want that an economy is developing and at the same time limiting its excesses, this cannot be done by the state. This can only be done by economic actors themselves under the pressure of the state or of protest movements or the NGOs and all that. So this is the somewhat complicated relation. It is, of course, not a voluntary self-limitation of the economy or of medicine. Think of cloning human beings, right? Or think of Fukushima in technology. Or think of the digital area, now what Google is doing and all that. So politics can first come with negative restrictions, or really destroy certain aspects of this activity. But it cannot really develop those actions in a reasonable, self-limiting way. This is only possible from the inside, But what is needed is outside pressures.
Also, thank you very much for a very, very interesting and soul-provoking lecture. Well, actually, you predicted one of the questions, how things will develop in the future, and you said that nobody can predict. So that's probably I will not ask that question. But what I would like to ask is, you spoke about internal regulations, about the tendencies which you see, so the corporations, let's say, trying to develop internal regulations which limit themselves. So they kind of put a framework and then they operate within this framework. And sometimes this framework becomes uncomfortable, then you try to break it, to break the rules they impose. If you take a political power which also limits itself, there is an explanation why it happens, right? It happens because of the interests of the individuals, so the individuals are pressuring the state and they protect themselves. What would make the corporations
limits itself?
Yeah, why would they why would they do that? And is it still the pressure from external pressure is the only driving force for them to limit to put a limitation, or there is something beyond that?
Yes, no, that's a good question. I mean, it goes beyond this question now, because, of course, the first answer would be no voluntary action is involved, and we should not rely on the morality of the managers.
The values part.
We should not rely on them, right? Rather, what we should rely is massive power pressures from the outside, which move or even constrain them to create these internal self-created systems. This is the first part of the answer. Now, what you are saying, or what you are asking, I think, yeah, there is something. I think of critical professionalism. I mean, critical legal studies in Harvard. What are these somewhat crazy professors teaching their students? They will be the elite lawyers of the country, trained in Harvard. And there comes in Kennedy and all these people, and they train them in critical thinking. And I think, although they never would say that, what these professors are doing is imbuing certain values, certain orientation toward a critical professionalism. That the lawyers they are training are not only looking for money for themselves or for the corporations, but that they also develop a sense of responsibility toward society, toward other people and all that. And this is what the critical legal studies movement tells them, teaches them. And they even have clinical practices so that they go out into the world and all that. So I think, you see now the tendency of my answer. There is, even as an empirical phenomenon, we can observe whistleblowers, we can observe statesman-like attitudes of certain managers, only too few, unfortunately, and not the Volkswagen in Germany. Perhaps BMW is a bit more statesman-like. Yeah, see this. So I think there are, and we have to take it serious, also from the workers' side. I mean, the engineers right now, they are furious about what Volkswagen has done. They're furious. I mean, the managers have given us the commands to do these the criminal acts. You know what I'm talking about, right? And they had obeyed, or others have not known, and now they feel they are the culprits for all this. So there is a certain professional pride within the engineering profession, which helps toward this self-limitation. And also, if we look at ourselves, lawyers that we are, but also philosophers, also, I mean, there is a certain professional sense of self-limitation of certain totalitarian tendencies of our disciplines, right? So the total juridification or the total philosophification, if this word exists, of our world, right? So yeah, I take this serious. Although at the beginning I said, don't trust the managers and don't trust the internal values. At the end, there is a considerable degree of shall we call it internal resistance, which translates into self-limitation. And one additional argument here is the following. I mean, we speak of the economic system and the political system and the legal system and scientific system, all that. And we mean by this not only, as one would think spontaneously, he's speaking about the professional organized sector of politics, the professional organized sector of science, and so on. No, the different social systems consist of two parts, if you do it schematically. One is the organized professional sphere, and the other is the what I would call wrongly spontaneous sphere. So in politics, we have the politicians and the whole machinery, and we have the public, the voters. In religion, we have the priests and we have the believers. In law, we have the courts and we have the people that are subjected to the law and so on. And if we think of how a social system limits itself, it need not only to rely on the professional organized sphere, but especially on those impulses that come from the so-called spontaneous sphere. So, although, I understand that both these questions are nurtured by a certain skepticism toward this societal constitutionalism, and I share the skepticism, right? There is something to be said about real forces in society, even then within the institutions, that move toward a self-limitation. And one interesting idea, which I have not invented, but which was a young French scholar, Trousseau is his name, he said there is something non-idealistic about societal constitutionalism. There's a real power effect of this. And it works like this. If you think of the interrelation of the European Court of Justice and the national constitutional courts, they're always fighting and cooperating and all that. So it's one calls it a war of judges, right? So of course this is a power play between them, but this does not tell us anything about the power enhancement. But this takes place when, the European Union, the basis of is the Treaty of Rome and following treaties. They have no constitutional character in themselves. They were not intended as constitutions. So it was the court who, in a sense, elevated the ordinary rules, some of them to constitutional rules, and created a constitutional framework in Europe, right? And now the interesting thing is that the European Unions and the WTO, they have also this war of judges among themselves. And now what they are doing is they are mutually recognizing the constitutional character of their regimes, the European regimes and the WTO regimes, although they don't have it from the very beginning. It was just an invention of the judges, but with this process of mutual observing and mutual applying their rules and mutually acknowledging the constitutional character of certain rules, their power aspect is elevated, and so they are creating constitutional power out of nothing. I think this is quite an interesting aspect which mitigates a bit the skepticism which I can feel, and I have myself. What societal constitution or global constitution? This is just an invention of the professors. No, these are ongoing processes, and they are even creating hard power structures.
According to the logic of systems theory, we have three types of systems: interactions, organizations, and functional differentiated world society. Now, what happens within organizations? And why I'm asking this question? In German legal doctrine, we have developed terms like Unternehmensverfassung, Organisationsverfassung, Verbandsverfassung. So this means that there exists organizational constitution. But what about processes of double reflexivity within constitutions of organizations? Because there we have no binary coded social communications. Organizations as autopoietic systems are reproducing through decisions and not through communications. What about this problem of constitutions of organizations, especially multinational organizations? Thank you.
Very good question, and this is the question, what kind of social configuration can be a constitutional subject, right? So, for example, could we here as a group create a constitution in a serious sense? which would be the interaction you are talking about, or the other thing, a seminar is a social system, can it have a social constitution, and so on. These are quite important questions. We know that nation states are creating constitutions. This is always our model, and in system language, this would mean it is the political system of the world, which is subdivided into the different political system of the nation states, and they are developing constitutions as a kind of institutionalization of higher fundamental values or something like this, right? And now, what about other configurations? I was talking about function systems like the economy, economic constitution, or science, scientific constitution, perhaps medicine. I mean, people at the moment are talking about and are analyzing, for example, the global constitution of the health sector, right? Finding out what are the fundamental rules and so on. Now, when it comes to organization, and I mean, you refer to the German tradition of speaking not only just about company law, but of Unternehmensverfassung, enterprise constitution. If I use this word in English, they look at me with blank eyes. What are you talking about? I mean, enterprise. You mean company law, right? And so here we find quite an interesting difference in the, let's say, terminology and the conceptualization of different phenomena in different legal cultures, like the German culture and the Anglo-American culture. But we find also different cultural tradition, and I would argue with Koselleck that the Unternehmensverfassung, so the enterprise constitution, is in a sense the continuation of the medieval corporation and its constitution, right? Of course, of a different character, and probably one could not even call it technically a constitution, but this is the interesting thing that especially in the so-called corporatist societies in Europe, you have this strong notion that certain organizations are not only juridified very strongly, but also have a constitution of their own. And I wonder how one in Georgia would see this in legal cultural terms. But the question then, now, how does it work with this double reflexivity? And the simple answer is, as you already alluded to, is the legal part is clear. There are internal rules to the organization, which in an expanded view of what law is about, we have to call law, although they are not created by the state. So the internal rules of an organization have a genuinely legal character, and there even we can identify certain rules as constitutional, as the higher law within. But now what about the other side, the social side, which was your question? And here the first answer is decisions that are becoming reflective. So organizations are nothing but a whole concatenation of decisions. This is what makes the core of an organization. And if decisions become reflective, they become the decision premises. So within the corporate structure, within the organizational structure, certain organizational decisions that are not of a substantive character, but more of a formal procedural character, right? And then I think we would have to add the coloring of these decisions via their closeness to certain functional systems. So we could not argue in systemic terms really that an economic organization, a corporation, an enterprise is part of the economic system, as strange as it sounds. No, it's not. In technical terms, it is in itself a social system of its own, but which has a certain closeness to the economy as its kind of primary orientation. And you see how correctly this is if you think of economic organizations and their different departments. So there are only some departments related to the economic aspects of the organization. So buying and selling, while production is oriented toward engineering, science, and political lobbying and corruption is close to the political system and so on. Huh? So you see, there's always this multifaceted character of also economic organizations, which we cannot make to define them as part of just being part of the economic system. So the answer would be double. Huh? One, it would be the reflexivity of decisions, decisions about decisions, decisions on decisions, which makes their constitutional character. And secondly, you would say again form content. The content then would be in economic enterprises would be of an economic character, while if we speak about universities, it would be different again. Huh? But in both, in universities and in corporations and in third sector organizations, you can rightly speak of a constitution of these configurations, which changes the type of analysis as we have experienced in the law, as constitutional lawyers distinguish themselves in their methods, in their analysis, in their content from ordinary lawyers, right?
If there are no other questions, then we'll go to the ceremonial part. And I'm very honored to say that the Academic Council of India State University has decided to honor his contribution to the study of law and society and politics to award Professor Toibner the honorary degree of our university. It was a great my pleasure to kind of present you with the robe, first of all. This is how I do it. Yes, please.